Everybody, welcome to the session. We've invited Robin David, sir, from Dua and Associates. He's a litigation partner at the firm, and he's celebrating 30 years of completing his practice as a lawyer. Okay, and my name is Abhyuday Agarwal. I've logged in from Komal Shah's account, and today our discussion will be on how to file public interest litigation, what is the importance, and who can file it, and how, and what is its relevance in a COVID and a post-COVID world. So, sir, it's great to have you here. I've known you for, I think, the past 6-7 years when we first met earlier, and you've acted a lot for, you were earlier representing, I think, a lot of pro bono work also you were doing as part of the Indian Christian Legal Association, and now you're part of another organization also where you have a governing body, a governing member role. So it'd be great, sir, if you could let us know a little about your experience as a lawyer, and what you did before being in Dua, and also now as a partner in Dua and Associates. I think you've completed about 18 years as a partner also in Dua and Associates.
Yeah, thank you, Abhyuday.
Yeah.
And it's indeed a great privilege and pleasure to be here. And thank you all for joining this webinar. First of all, I think in these COVID times, we must all be safe. And I'm glad that you're all taking precautions. And the definition of pro-COVID definition of a learned friend was between lawyers. I think now a definition of a learned friend is someone who stays safe and avoids contacting COVID. So everyone is my learned friend now. And after 30 years, it's been quite a challenging time, interesting time, and very enjoyable. And I have tried my hand at several areas of law. I worked in the trial court for a good amount of time, and then in the Delhi High Court, and had experience when the MRTP Commission was functioning at its peak, then the Competition Commission of India, then later on in the Supreme Court. And it's been quite challenging. And I've had many good experiences with seniors, juniors. Coming to the topic, in this COVID times, the Supreme Court has been very busy looking at public interest litigation. Supreme Court no doubt takes only urgent matters through video conferencing now. And Supreme Court has heard several matters. And with the help of some of my colleagues, managed to collect some of the decisions. And one such case is of Indians stranded in Iran post-COVID, and they petitioned the Supreme Court to come back to India. Then there's a case of migrant workers and regarding the spread of pandemic and how to protect them. There was this situation. Then there's also the case where the states and union territories were asked to make safe transit to prisoners during national lockdowns. Then also there's a case of juvenile justice boards, children's courts to consider releasing children from observation home on interim bail during this COVID period. Also, there is this ongoing case of J&K where they were petitioned by some public spirited citizen to restore 4G in Jammu and Kashmir.
So there was a public interest litigation filed regarding the disaster management instructions issued by the government also, no?
Yes.
Recently?
Yes. That's right.
Okay, so basically you've given us a very interesting list of cases that have been filed. And so on all important issues at the moment, there are...
And more recently, there was one case of Gerald Bennett on 8th of April, where they asked for protective equipment, PPEs for health workers, and the court
Oh,
did
great.
direct. That is most significant because it has, in this stage, it will enable us to understand what exactly is public interest. Public interest is the interest of the doctors, and the doctor could not file the petition. Some public spirited person filed the petition. So the issues of who can file a PIL is also very important.
So all the examples you give, sir, are all topical issues, things that are
Yes.
happening right now.
Yes.
With and many of these are COVID related only.
Yes.
And so how are the hearings and everything conducted at the moment, and what is the space at which things are going on? Have these slowed down? Is the court focusing on these with a high priority? How does it work? And what if somebody decides to file a non-topical PIL, like a PIL, but not on something related to COVID?
Uh, I think so far this court has seen mostly PIL which are connected to COVID because of the emergency. One of them is where lawyers and law clerks were stated to be close to starvation. So the Allahabad High Court also stepped in and said the Bar Council should take steps. So we've seen mostly COVID-related cases, some commercial, and some of this nature, what I've already spoken about.
Okay. So I'm going to ask. So somebody Gaurav has asked to describe how PIL start from the very beginning and how to file. So we'll get there, Gaurav. And there is another request to share one example and then illustrate. So maybe about the PIL regarding stranded Indians. You could share on that, or so you could share on the Supreme Court order directing private healthcare institutions to conduct COVID diagnosis free of cost. This would be an interesting one because the test has been an expensive one, and if we or
Yes, Supreme Court did take up that matter, but yesterday that order was modified because it wasn't free of cost to all. It was
okay,
modified to the extent that it is free of those who can pay should be asked to pay for it. So it was on a means come basis.
okay, and
So
how does
there
the
is a change
hospital
in that.
figure out?
Beg your pardon?
How does the hospital figure this out that they are left free to choose a way?
Well, I'm not sure because
Okay.
it could be normally there's a way of ascertaining someone's means, but
Hmm.
here it may not be that straightforward. And I
Hmm.
think because of the emergent nature of the situation, we
Hmm.
can't have a very certain solution to this.
Right. And so, how did the Supreme Court modify the order? Like, what was the process
The
of doing that?
central government moved an application
Okay.
and said that I think it was the cost to the exchequer was an issue.
Hmm. Hmm.
And thereafter, the court, after hearing the parties yesterday, modified the order.
Okay. So since the cost on the central exchequer was higher because the entire burden of testing was on the government hospitals, that's why you're saying that.
That's right. Yeah.
Okay. Uh, so I think it'll help us now to take a step back and see how PILs are actually filed, how they are useful for lawyers in the long run, and how does the court decide upon the issue of having a locus or not. Should individuals file PILs in person or should they engage lawyers? And at the same time, what what should lawyers charge? What should lawyers charge for helping out public spirited citizens or organizations?
Okay, there was a lot of questions.
Yeah, so this is actually the agenda for today, sir. So
Okay.
we
Okay.
can move into this flow one by one.
Yes.
I think, but I'm trying to sort of interpret the messages that are coming because everybody's asked very specific questions, and these are the flavors that I'm seeing. And so, everybody, we are going to address these questions that you've posted, and I'm trying to put a framework to our conversation so that we can move in a smooth flow. So we start off with, so I think the first thing that you've said is the PIL should be contextual and
Yes.
relevant to the need of the hour because the court will have some sort of discretion in admitting it or in the priority they place.
Yes.
Okay, and how does one decide that one is okay? COVID is very clear, like it's stark that this is an issue. But is the relevance? Is there some relevance on the bench which is sitting or the roster and what they are focusing on? Should we pay some kind of regard to that?
No, that I think it is the council who will have to take a call, because the
Okay,
council knows his court, and
right.
it will not be easy for generalization to be made on that issue. But I think let us step back and look at some of the guidelines on this topic.
Okay, great. People have
And
asked us.
since we are we're talking about matters before the Supreme Court,
Hmm.
Part 3 of the Constitution dealing with fundamental rights is of importance. I mean, it is the most important part that we are talking about in uh, as concerns this topic. Secondly, within Part 3, we have Article 32. It is the right to approach Supreme Court to enforce Part 3 rights, enforce the fundamental rights, which are starting from Article 12 onwards, Article 12 to Article 35. That comprises Part 3. So the fundamental right, 32 itself is a fundamental right. So normally in PILs, Article 32 petitions are filed to enforce fundamental rights of people who, generally it's not the petitioner, it is the public or in public interest. What kind of matters are included in this? One is bonded labor matters. We have an example of Bandhua Mukti Morcha case sometime in the early 80s. And then we have matters of neglected children, exploitation of casual laborers and non-payment of wages to them, except in individual cases, a general sort of matter. Matters of harassment or torture of persons belonging to scheduled castes, scheduled tribes, and economically backward classes, either by co-villagers or by police. Matters relating to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forests and wildlife, petitions from riot victims, and other matters of public importance. This is according to the Supreme Court rules. These are the headings.
Okay. And the
Also,
rules
it'll
have sort
be,
of consolidated some of the matters.
yes,
The themes have been identified from some of the past matters that the court has heard.
yes.
Right.
For example, based on these the environmental issues, the various principles were established, like the polluter pays principle, polluter pays principle, the precautionary principle, etc.
Right.
So also I'd like to point out matters of private nature which do not fall within the contours of public interest litigation. Threat to or harassment of petitioner by private persons, seeking inquiry by an agency other than local police, seeking police protection, landlord-tenant dispute, service matters, admission to medical or engineering college, early hearing of cases pending in high courts and subordinate courts.
Okay. So Anil has asked Article 32 is used for PIL and writ petition. It's the same. Yes, Anil. It is the
Yes.
same. Mohit has asked, is there any difference in approach while dealing with regular matters to that of filing PIL? And which floor test does the Supreme Court employ to identify whether the PIL is genuine?
Yes. See, what we are used to is, which is not in PILs, is adversarial litigation. So in adversarial litigation, the petitioner knows his rights and he approaches the court for redressal of either fundamental rights or any other commercial or private rights. But under Article 32 in a PIL, there's an action placed in a court on behalf of someone else, you know, someone who can't approach the court in public interest. I'd just like to read a report of how this started in 1973 and in 71 by Justice Bhagwati and Justice Krishna Iyer. And Krishna Iyer, while dealing with how there should be a nexus between law and poverty, and spoke of PILs, and he said there is a need for an active and widespread legal aid system that enable law to reach the people rather than requiring people to reach the law. I think this is very significant difference in PIL. First of all, it is not adversarial, and if public interest is served, all the parties it would be a win-win. There be no losers if public interest is served. It is petitioning the court to take action against the executive for either non-performance of its duties or asking them to perform its duties. So if all are interested in public interest, then it's a win-win situation for all, unlike the adversarial proceeding. Likewise, the petitioner's locus standi is a very important issue. The authority to move a court, authority to knock at the doors of justice. Normally, a person whose individual rights are affected only can approach the court to redress his grievances. But in a PIL, the locus standi is much wider. Person who's not really affected can go, so long as the public interest element is taken care of. And what constitutes a public interest petition has been dealt with in a judgment of Supreme Court in 2010. It is the state of Uttaranchal versus Balwant Singh Chaufal. If it'll be important for us to understand as we go forward in this topic today, to understand some of the aspects raised in this judgment regarding what should be a good PIL and how to maintain the sanctity of PIL. Shall I just briefly talk about those points right now?
Yes, sir, you could let us know those points. And the related questions that people are asking are what's the difference between written PIL, whether PIL can be filed against financial institutions, do PILs lead to judicial overreach, and why ML Sharma has not been barred from filing PIL at all, because since most of them have been dismissed, that's what somebody has asked.
In fact, ML Sharma, yesterday, his case where he challenged the PM care policy was dismissed, and they threatened to impose costs on him, but I don't think they did impose.
Yeah, so I think imposing costs is okay, but one cannot be barred from filing itself. The court may dismiss a PIL for its not being of public interest, and it can impose costs to discourage frivolous litigation. But
yes,
one cannot be prevented from approaching the court and the registry itself, because that would violate our fundamental right
yeah.
access.
But it has happened in some cases. I've seen it happen in few cases where the petitioners file very frivolous petitions. And for example, in this case, which I'm going to cite, is the case of State of Uttarakhand versus Balwant Singh Chaufal, 2010, Volume 3, SCC 402. In this case, the petitioner in the state of Uttarakhand challenged the appointment of Advocate General under the Constitution, which says that the Advocate General should be qualified to be a High Court judge. And this Advocate General was more than the age of 62. And qualification for a High Court judge was you would retire at the age of 62. So they filed the petition, but it was thrown out. It was allowed by the Uttarakhand High Court, but dismissed by and cost imposed by the Supreme Court, because this issue was already decided in several decisions of Madras High Court and also the Supreme Court. And they said that a lawyer who files such a petition should be diligent, and he should do his research before filing this, so filing such PILs. He can't just walk into court and file PILs. So still staying on the point of this Balwant Singh Chofal case, I was talking about the points raised in this judgment, I think, which are now the guiding principles for PILs in India. First is, which is a very general point, but very relevant. It is that the petition must be genuine and bona fide without extraneous considerations. Then the credentials of the petitioner should be prima facie verified. The contents of the petition should be correct. There should be a substantial public interest. The petition should be aimed at redressal of a public harm or public injury. There should be no personal gain, private motive or oblique motive behind the PIL. Petitions filed by busybodies for extraneous and ulterior motives must be discouraged by imposing exemplary costs or by adopting similar novel methods to curb frivolous petitions petitions filed for extraneous circumstances. So I think this would give an indication of what should be in a PIL.
Yeah, I have two questions in connection with this, sir. If there's a frivolous PIL, what is the kind of cost that the court has imposed? Like, I understand it must be discretionary, but what is it that they impose on the council? 20,000, 50,000, 1 lakh? Have they gone higher?
It may not be right to actually say, because it depends and it changes with time. This was a petition filed sometime in 2010, decided in 2010, and I'll just check what was the cost imposed.
I think more than the fact about the quantum of cost, I think the whole issue is about the signaling that it gives against the lawyer when you are filing that kind of a PIL, and I think that is what a lawyer needs to be mindful of. Because the upside of filing and winning a PIL is that you can be famous, and the downside is that if it is frivolous, one thing is that it's not admitted, but if it's regarded as frivolous, then and costs are imposed, it's a reputational issue within the courts. I think that is important.
Quite rightly put.
Okay, and so I wanted to ask you one question. Is it now still the case that the petitioner has to have no connection with the issue, or is it that you have to have there's a public interest involved, and the petitioner also has a private locus, in the sense that the petitioner stands to gain at his or her work or personal rights through the directions issued by the court? Is it both, or is it just the fact that only public interest has to be involved?
It should be only public interest. There's no two ways about that.
Isn't there a problem that, if I identify something which has public interest involved, but I don't stand to gain or lose, then the thing is that the court will say that you are just filing PILs for the heck of it?
No, I think it will depend on, because if you look at what should be a content of Article 32 petition, if you look at the Supreme Court rules, it says clearly that the nature of injury caused or likely to be caused to the public. That has to be very clearly spelled. Okay. And these things are being checked quite rigorously by the courts.
And should the petitioner also stand to suffer any injury from that? No connection is needed.
I think he should not, actually.
Okay, because what happens is a lot of times people say, okay, this practice by telecom companies I want to challenge, or an internet company will say, okay, TRAI has a discriminatory provision against us. So there may be public interest also involved, and that the petitioner also may have something to win or lose. It's not a private matter, it concerns public interest, but there's also a subset of a private connection. So you are saying that is not necessarily relevant.
In fact, you should clearly state if there is any nature and extent of personal interest, if any, on the petitioners. That has to be spelled out.
Okay.
So it's very I mean, you have to be detached. I think the sense
Detachment is
that I'm
important.
getting from the quote is you should be detached from the cause
Okay.
and objective rather than
Okay.
try and gain some personal gain.
Okay. So what are the so people are asking basically are watch CA, I can't pronounce your name, I'm sorry. Orders under PIL are as good as law under Article 142 or not? Yes, definitely. In fact, Supreme Court has said so many new principles of law through its judgments under which were filed through PILs. I think the answer to that would be yes. It's a clear yes. They are as good as law under Article 142. But the next part is how is it enforced? So,
In fact, once an order is being passed, a court should, PIL court, the court passing the order should also see that it is enforced. I mean, see that, anticipate its enforceability or not. They can't pass impossible orders that can't be enforced.
because a lot of times there are orders which are creating new law. They might be vague also, or directly the court may not set a monitoring framework. Sometimes the court sets that the state government is to ensure that the, let's say, the pollution control board implements X and supports and sends them a report. So that's the kind of framework I think the courts usually make, so that some authority is put in charge of implementation.
I think courts always in with good intentions makes orders, and sometimes they do not foresee entirely what is the outcome.
Hmm.
So I think we should give it to the court because the court has done very well. Like in the Bhagalpur blinding case, they ordered for legal aid. That was way back in the 80s when this
Yeah.
law was emerging, and then the courts have worked very hard on environmental law. That is, courts have worked on transparency and accountability in public life.
Hmm.
So there are many positives
And I think
there.
if there is a gap left in the implementation framework, that can be followed up with a new PIL that these were the directions and they are being flouted, and
Yes.
the court can issue directions to ensure that the earlier judgment is upheld or is honored by the bodies.
Even Justice Lokur's court, about 2 or 3 years back, it took very hard stand against the government for not enforcing some of its directions.
Right. Do they file those contempt petitions, civil contempt petitions, and all of that for non-enforcement of PIL orders?
I've heard of quite a few of them being filed. Yes.
Okay. Now, okay, Abhilasha, will the PIL be dismissed if the petitioner has any personal gains involved in it?
Yes, definitely.
Okay. So, what is the procedure to file a PIL? This has been a constant question. So, two questions still pending on procedure to file a PIL, and second, the point of judicial overreach. So, we'll get to judicial overreach in a bit. Let's just look at the procedure. A related question to the procedure for filing a PIL is whether a question of law must be framed or not in the PIL.
Okay. Okay. I'll just go back to Supreme Court rules.
Yes.
It's called Supreme Court of India Handbook on Practice and Procedure, 2017. This I was given this by my AOR colleague. Uh, I did mention what are the general types of PIL matters and what are not. Then uh, I'll go on and say that a writ petition in public interest would be under Article 32, and it should be filed in Form 33. And these are the following disclosures that are required. One is the name of the petitioner, his complete address, etc., email, PAN number, etc. The facts constituting the cause of action. The nature of injury caused or likely to be caused to the public. And I think this is significant. And then uh, the nature and extent of personal interest, if any, of the petitioners, details regarding any civil, criminal, or revenue litigation involving the petitioner or any of the petitioners which has or could have legal nexus with the issues involving the public interest litigation. This is important, and I think it covers some of the points that we've discussed so far. Whether the concerned government authority has moved for relief, whether the concerned government authority was moved for relief sought in the petition, and if so, what was the result? Sometimes you do jump into court moment you think you have a case. So the point that is being raised here is, did you approach them and ask them that they should remedy the situation, and if so, what was the reaction? So it's encouraged that you try and sort it out before rushing into court under a PIL. Of course, all the standard stuff is there of affidavits and declarations that this issue was not decided earlier in a similar matter, and court fees, etc. So these are the bare bones of what is required under the procedure.
So someone has asked to repeat point 4, which was related to criminal law. Was there any point related to that?
Details regarding any civil, criminal, or revenue litigation
Okay.
involving the petitioner or any of the petitioners which has or could have a legal nexus with the issues involved in the public interest litigation. So this is supposed to be disclosed.
Okay. Sandeep has asked, can a PIL be filed on the basis of reasonable apprehension of something happening, or it has to be against an ongoing process like an arbitrary executive action?
It's a very good question, Sandeep, because sometimes before the wrong happens, and if you apprehend that it's going to happen, it would make sense to take action and stop that. But many times courts would not entertain such petitions saying that it is too illusory or it is your imagination. So it has to be backed by something very solid, that whatever apprehension is there, it has to be very solidly backed by some sort of evidence or
That this
logic.
is apprehended. That
Yes.
has to have a basis, otherwise it will be very fictitious.
And definitely this wrong is going to happen.
Right. Then Venkat has asked, is there a prerequisite that prior to filing a PIL, a proof of inaction or non-resolution with the executive on the issue needs to be there? In other words, can someone file a PIL without addressing the issue with the executive? I think his question is more about trying out an alternative remedy if available under the law. In some cases, there's no remedy spoken of, so he's asking whether we should, I think he means to ask that, whether we should consider resolving it directly first.
I think we should try and resolve it first.
But what if the executive order doesn't have any avenues to do that? Forget, then nobody would even think of approaching the executive first.
Yeah, but if I think that would help your cause. If nothing is done, it will help your cause, saying that the executive neglected it. If executive can't do anything, then who can?
And I also think that sometimes courts leave a lot of discretion with the executive. And one risk you will run if you do not approach the executive first is that you cannot tell a court, you cannot request a court that how the executive inaction is affecting my rights, and the court will say, no, this is a discretion of the executive. And why don't you first go to the executive to see how they can manage this kind of situation also? So because they will not want to get into the decision-making part of the executive. They will only get into the unfairness. So a court will not be so easily able to decide that what you're asking for is merely unfair, or is it actually infringing with the decision-making autonomy of the executive. And they may not, for that reason, interfere with the executive order. And this is where your first approaching the executive may make a difference. Because then you can say that, this is what I requested, and here there's a fairness issue. the decision-making autonomy they can reserve, but this fairness issue should be taken care of. And this is exactly the kind of directions courts prefer to give. They would not want instructional directions exactly telling the executive what to do, except in rare cases like the polluter pays principle and all. They are very detailed lawmaking of the courts. But in other cases, what the court will do is they will give some criteria, some choices to the executive body so that they can frame this keeping in mind their own governance concerns and protecting your fairness. But
True.
Sir will share light from his experiences on this. So have you seen this happen? Like, courts, people say a lot about judicial overreach, but I know at the same time that when litigants think of filing PILs, they are very careful so as not to think of outrageous reliefs or things that would be like amount to judicial lawmaking. People try to demarcate, what is the discretion of the executive. So that is decided in the prayer of the litigation. And people want to have a prayer which is sort of leaving that freedom to the executive and also getting them that relief.
Yes. And also, courts also are very conscious of the doctrine of separation of powers.
Yeah.
And as far as possible, they will not interfere in policy making and tread on the territory of the legislature. So I think courts know that line and they do keep distance.
Right. So Gaurav is asking, like in case of PIL with regard to under trial prisoners, how the points to be presented to the court and what would be the criteria to raise that specific issue. Please explain with any example. I cannot fully understand the question, Gaurav.
I think under trial prisoners, they have been a good number of cases, and even way back in 81 or 82, there were cases of Husainra Khatun and that Amit Yadav in 79 or 80, which dealt exactly with this. And I did mention of the Bhagalpur blinding case where they were blinded by the superintendent of police in Bhagalpur, and the courts interfered and shifted them to Delhi for medical treatment and legal aid, because they had a right to legal aid and they were not told that they can get legal aid at that time.
Right. So one more question. So what is a PIL is filed under Article 32 of the Constitution of India, and we've said that
In the
public
Supreme
interest is
Court.
in the Supreme Court. We've said that public interest is paramount. So how does somebody explain the connection with fundamental rights while filing a PIL? Does the person have to make a case for fundamental rights of individual citizens of the public being impacted, or that connection doesn't need to be drawn?
Absolutely, he has to, because if you look at Article 32, it is talking of the right to approach the Supreme Court
Where
for
fundamental rights are.
enforcement of rights under Part 3.
Right.
Part 3 starts with Article 12, when Article 14 is on equality, 19 is all the freedoms,
Right.
21 is the right to life, which has been very widely expanded over the last 70 years.
The most frequently invoked ones are 14, 19, and 21 in all of these, right? So
Yes.
whenever a PIL is filed. So you'll have to draw that connection, everybody, when you think of filing a PIL. So is it preferable that lawyers are engaged for PILs, or should petitioners in person draft, file, and argue PILs? What is your take on the issue?
I think the case should be made out. We do have a good judiciary, so as long as the good case is made out, it won't matter if there's a lawyer or there is no lawyer.
Okay.
But it's important how well it is made out, and I think the steps have to be taken. Go and knock at the doors of the executive and tell them this is what is the wrong that is being done, and kindly remedy it. And if they don't do it,
They
then
should
you
give a
approach the
time-bound
court.
notice with some opportunity to respond, at least if
Depending
not.
on the urgency, it should be, say,
Okay.
could be 7 days, 20 days, 30 days, or
Right,
if it's a life and death issue, then you may not have to. You should not give a notice. You
right,
should not give that. You should just go into court and say how important this is. But I think making your point and getting it across is most important. And I've heard you earlier talk about how much should a lawyer be charging for that.
yeah. One person asked that question.
Yeah, I think you should be asking that question, at least to me. Yeah.
So I think it'll be, I don't know, like in a public interest litigation, probably lawyers, all they would do is charge for costs of printing, stationery, clerkage at best. And then I know a lot of lawyers who don't even charge that if they find the litigation worthwhile, like if
Yeah.
it's a genuine litigation.
I think depends. If it is someone who is like migrant workers, uh, how will you charge them? Yeah,
Yeah,
they're starving, not having food, and then and luckily the court fees in the Supreme Court is some 50 or 100 or 200 rupees, something like that. So you just pay that and move on and see that they get the relief.
right, right. And I think professionally, it has a lot of benefit for lawyers in terms of their credibility and face value before the courts if they succeed. So I think that kind of uh, covers up the cost,
Yes,
the
and
lack of
and also we
involvement.
have the legal services authorities in all the courts right now, which are reasonably well functioning. So you have in Supreme Court a legal services authority. You have a legal services authority in the high courts. So whether it's Article 226 or 32, I think you can get a relief
Right.
through that remedy.
So there have been in the past PILs filed through, let's say, even a letter being addressed to the court. And do you remember? I think there was suo motu cognizance also that has been taken. I do not remember very clearly offhand, but Ajay has asked whether the court can take cognizance of any PIL as suo motu. And another person has asked whether what allows the Supreme Court to sort of take cognizance of a letter addressed to them. So it'll be great if you can address these questions.
Yes, in
What?
fact, I think the latest case is by the Member of Parliament Mahua Moitra on the migrant workers issue, which was taken up by the Supreme Court. And letter petitions can be made in certain cases. Some are the I think I'll just mention them here. They're all enumerated here. One is bonded labor matters, neglected children, non-payment of minimum wages, and exploitation of casual workers, and complaints of violation of labor laws, except in individual cases. Petitions from jails complaining about harassment. Petitions against police for refusing to register a case, harassment by police, and death in police custody. Petitions against atrocities on women, uh, especially bride burning, rape, murder, kidnapping. Petitions complaining of harassment or torture of villagers by co-villagers or by police, from persons belonging to scheduled castes and scheduled tribes and economically backward classes. Petitions pertaining to environmental pollution, petitions from riot victims, family pensions, and the Supreme Court accepts letters in these cases,
Okay.
and it has to be all letters will be sent to something called the PIL cell, and they'll be screened by the PIL cell, and then they'll be placed before the Honorable Chief Justice of India for directions. Uh, then, if a letter petition is to be lodged, the orders to that effect should be passed by the registrar or any registrar instead of additional registrar or junior registrar. To begin with, only one judge may be assigned this work, and number increased to 2 or 3 depending on the workload. So
Okay.
this broadly touches upon what is how a letter petition can be filed. You also mentioned about suo motu,
Cognizance. Yeah.
suo motu cognizance. recent case was in Allahabad High Court where there was a case of name and shame. I don't know if you remember.
Yes, yes, sir.
Name and shame of the
Right.
rioters, etc. And the High Court took sumo cognizance of that, saying that why should their names be published? Because published on a banner before they are actually given an opportunity to pay the fine, because it encroaches on their right to privacy under Article 21, which was very well covered by the Puttuswamy 9-judge bench. So, sumoto is a term given to the action initiated by the court by itself on its own motion. In normal circumstances, a party approaches the court and files a case against another party. The nature of the proceedings is adversarial in nature. However, in certain instances, the court initiates action on its own. So, I mean, I've just read the definition of sumoto. So, court sometimes does take up on its own. In fact, um, sometime 2 or 3 years back, there was a student who was blind; he couldn't see, and he was trying to get onto a train to come to Delhi University, Delhi, for a admission to a certain course, and he couldn't find the door. Couldn't get into the train. Missed the train. Missed the interview. Justice Geeta Mittal saw this in the newspaper and issued took notice of it. I was fortunately in court on that day when it happened for another matter, and she issued notice, appointed an amicus, and went on to hear the matter. And ultimately, the university, I think they interviewed him, and though he was late, they condoned that.
Okay, so the questions are back on what you were explaining earlier about the steps, stages involved in PIL. I think somewhere in the middle I asked you more questions, and so the conversation went off track. So we want to come back to that you were explaining. So you explained to us, I think, the format. Then the court fee part is there, and then what are the steps and stages involved in filing PIL?
Yeah. I think the most crucial steps are what is the injury that is caused or likely to be caused to the public. I think the heart of your case rests on this point. So, nature of injury to be caused, whether under trial victims are being harassed, prison reforms are required for a person who's in jail, whether the, the police are taking uh, are threatening victims, harassing victims in jail. These are some examples that have actually happened. So,
Okay. So after the drafting, what are the steps in filing and the hearing stages, and how long does it take to decide? If you could give us an overview of this.
so once it's filed, then it comes up for hearing, and you will have to argue, make out your case, and then notice is issued.
The
And
admission hearing.
yes, and you would have to serve process and proceed with the matter.
So
I think the
anything. Hmm.
most crucial is the admission hearing, where the court should be actually convinced that this is a matter in public interest and public harm, and public interest would be subserved by way of this petition. Many times the locus standi of the petitioners is questioned. And like someone was already saying, it's very important to be conscious of a detachment from the actual cause. The least benefit you get from a petition, I think, the more reliable you will be found to be by a court.
Okay, sir. And are there any challenges at the registry that are faced here?
I think there is a PIL section that looks into the
Okay.
matters, and I don't think it will be particularly different because every petition has guidelines that have to be followed, and the registry does follow those. So long as you follow this, and there's a order 38 of the Supreme Court rules and there's also a Form 33. So these rules have to be strictly followed, the forms, because procedure is very important in the Supreme Court. So the lawyer or the petitioner should be very, very careful about it. Nevertheless, if it's a letter petition, it would be much. They won't be so strict about the forms and procedure.
But then they have to ensure that it is in that category, the petitioner who's filing.
Correct. You have to strictly follow those bonded labor, etc., like I did mention earlier.
Okay. So format will be available online for free, no? The Supreme Court website.
Format, I'm not sure, but I think
we'll try to dig it out.
I'll ask one of my AOR colleagues
Right.
to help out with this. No problem.
So would you have any idea about how long it takes to decide a PIL? Is there a range, or what have we seen in the past?
There is no time. You can't fix a time definitely on any petition. You could get it could get done in a couple of hearings, or sometimes the state, if you ask them very difficult questions, they may take time to respond, and there may be a monitoring factor involved. There may be statistics. They may not have all the data with them immediately, so
it can take longer than a couple of years also for a PIL to decide, and it could take
some
shorter.
PILs go on for many years. If you see MC Mehta matters, the petitions have went on for a good amount of time, and sometimes even old petitions, interlocutory applications are filed at a much later stage, and we have orders being passed after a few years.
Right. So Ajay has been asking whether PIL practice is different at High Court and at Supreme Court.
PIL practice is different in the sense, like I said at the outset, PIL is not purely adversarial. So compared to a commercial lawyer, a PIL lawyer would be a little different. But that being said, there are many lawyers who wear 2 or 3 hats at the same time. So you're a commercial lawyer, you're a PIL lawyer, and maybe you may do something else at the same time.
To have PIL practice be sustainable, one must also continue performing other kinds of work so that you can keep earning, I think. Somebody was asking what to do to build a PIL practice, so I'm saying that in connection with that.
I wouldn't think there's something called a PIL practice, because you're not very sure of your clients. It is in public interest, and so to expect a regular source of income from that may raise some eyebrows. How come someone is having so many PILs and also earning well?
Right.
So ideally, in my 30 years of experience, I think a good PIL lawyer is one who does PIL also. It's not who exclusively does PIL work. He's a good commercial lawyer who is sustainable, having some respect in the legal community, and he also does a few PILs for a good cause.
Okay. So, question, anything further you would like to say on the filing aspects of PIL, how the filing can be more effective in the Supreme Court?
Filing in the Supreme Court.
Of filing in Supreme Court.
It is, I think you go through these guidelines, go through there's a Supreme Court Handbook on Practice and Procedure 2017. And I'm sure you'll get all your stuff there. So you have to follow it very strictly, and
What is
have a good court clerk who will help you with the filing.
the homework that someone should do before filing PIL? I think, sir, this would be about establishing the right criteria about the injury, and which you were telling us about.
Yeah, first of all, you don't start off saying I'm going to file PIL. I think first thing you'll see is you'll have to identify the cause. You identify the cause, and then you decide uh, how you're going to go address the cause. I think that is more important.
So, would you say that when I am one is that when a client comes to you, it is upon the lawyer to identify whether this is a fit case for a PIL. Then at
Yes.
the drafting stage, when you're looking at the requirements for Form 33 and you identify the public injury, the personal association of the litigant with the matter, all of that, that's going to flesh out
Yes.
whether your admissibility, that will flesh out the admissibility part, whether there's a good case or not.
No, I think first, once you identify the cause, you try and redress it as far as possible. Try and approach the executive and see if they can solve the problem.
Right. And if a private party infringes the fundamental right of certain class of citizens, how can one enforce his rights? By filing a PIL, as PILs are being in the nature of writ petitions are maintainable against the state only. So would you like to
Sorry?
take that question? If a
Sorry?
private party is infringing the fundamental right of a citizen,
Yes.
then how can one enforce his rights by filing a PIL, as PILs are in the nature of writ petitions and maintainable against the state only?
If a private a person infringing a fundamental right, and I think uh, Article 32 may not apply to that case, no? Because it's the state shall, if you look at uh, it's the state shall not discriminate. If you look at the part 3 of the Constitution, equality, the state shall not take your life unless procedure established by law. So
Yeah.
it is not that you can file against a private party.
So one of the things that they can do is see if a private party is infringing your fundamental rights. There is already some of the provisions in IPC, so you can go straight away file a police complaint. Okay, if the state is illegally detaining you, that's a different thing. That's there the state is involved. But otherwise, if a
Correct.
private party is doing this, you will have provisions in IPC. Second
That
way
is
to
right.
do it is that if your fundamental rights are being violated, you can involve a state regulator and request the court for directions from the legislature or from the executive to that regulator,
Yes,
so that that aspect of your rights are not infringed.
that's right. That's right. I was saying from the you can't be filing a PIL in a case in such an illustration that was given. Yes.
Yeah, correct. So Pavanta has asked, what kind of articles or news can be relied upon to support one's PIL in terms of evidence? What kind of, how much evidence does the court want to consider that some issue which is being spoken about is actually happening? What kind of evidence does the court want?
The the uh, there have been instances when newspaper articles were good enough for filing a for a PIL, but you would require some level of evidence which shows that actual injury would be caused to the people. It should not be solely based on a newspaper report. It has to be backed by something else to convince a court.
Okay. Is there any, like, how do good lawyers decide that, this is substantial evidence, this is not? What will prevent somebody from going for a wild goose chase for evidence? Any criteria for that? So any indicative criteria you would know of?
I think for each case, you will have to look at the the facts of the case, and if there are any precedents, and how it's being addressed. Sometimes the uh, the inaction by the state and its ill effects would be very glaring. So at that time, you do go ahead and take all steps that are required.
Okay, Shamant is asking, is there a what's the reason behind fundamental rights being available against the state only? Why are they not available against other citizens violating your rights? I think it's that horizontal and vertical application of rights question he's asking.
See, like you said earlier, if your rights are being infringed by an individual, you could set the law in motion by uh, triggering the criminal law, by invoking criminal law provisions. So it's very clear that Article 32 and Article 226, etc., would apply only to the state action.
The fundamental rights were actually the drafting is such that it is sought to protect individuals from from encroachment of individuals' freedoms by the state. But there is a conversation on horizontal application of rights in constitutional theory, which you can read, Shaman. Okay, and maybe you can do some more research on how that's being applied. It's more in 226 than in Article 32. Nirmal has asked a question, sir, about.
No, I'll just like to go back
Yes,
to,
sir.
I think Shamal was the earlier question. No?
Shamant, yes, sir.
The thing is, for example, if your rights are being infringed by an individual, you approach the police fails to take action, then you can approach the court and ask the police to take action against the person who's obstructing you.
Okay. So I'm going to take one of our last questions. CA Nirmal Sumani. The Street Vendor Act 2014 has not been implemented by most of the states. Can a PIL be filed in this case?
What does the Street Vendor Act say?
To see it. Why don't you tell us, Nirmal? What is the part that you want to file a PIL for? Implementation of the act and doing what by the state? I'm opening the act. It is on issuance of certificate of vending, certain protective rights of street vendors and duties of street vendors, maintenance of cleanliness and public hygiene, all this stuff is there.
We should look at the
Relocation and eviction also.
What is the ministry that controls this execution or regulates the Street Vendors Act? I think you have to approach that ministry and see that, ask them, these are the issues that are not being implemented by the act. There is a law in place, but it's not being implemented.
So the specific parts, no?
Yeah, specific parts. When will the enforcing ministry actually take steps? And in case they don't do it, then you move a court.
Yeah, and G30, they cannot file contempt of court because there is no court order on it right now. There is a statute which is not being followed. So if there is a violation of a court order, then there's a contempt issue, execution or contempt issue. The ministry is Housing and Urban Poverty Alleviation, sir. Ritika is
Okay.
Okay, so Chandra Mishra and G30 was the person I think asked me. So what you have to see is which is the part of the law that is not being implemented. There are many points that need to be implemented under the law. If nothing is implemented, then you can specifically draft a PIL which identifies that these things need to be done and they haven't been done. So you can request for directions before from the court on implementation of that. But sir is saying after you go to the ministry, first make a representation. When that's not acted upon, then you go and file a PIL.
Against that ministry.
Against that ministry. The municipalities are not forming vendor committee there, sir. Nirmal is saying. Okay, good. So that's how you have to identify that these are the specific issues. Guys, we are going to wind up the session. One question was from Galaxy J7 Next. In insolvency laws, there is a clear violation of fundamental rights of the corporate debtor. I don't know how you're saying this. who's the owner of the firm. So PIL can drag against bankruptcy court before SC. You can file PILs and make a case as to how this is being violated. That is fine, but I do not know how you're saying there's a clear fundamental rights violation of the debt of the owners.
Also, the validity of the IBC was challenged in
Already.
various, and it's been upheld. So it may be a very uphill task to again challenge it now.
On the same grounds, so it will not work.
Yes,
You can run the risk of costs being imposed also.
that's right. And it'll likely come up before Justice Rohington Nariman.
Okay. So I want to end the session here, and I want to ask everybody about for feedback. I got one feedback from Divyan. She said that he wanted procedural aspects to be covered for filing at the Supreme Court more specifically, and he said we could have organized this better. So I got that feedback, but I want others also to rate the session so that we know how the session was for you from your learning perspective, and so that we can keep improving our sessions with every session. A lot of you attended, and thank you so much for being there. It was amazing to have you. Some people are still asking questions, sir. Would you have time for one or two questions?
Sure. Thank you all. It's been very interactive, indeed.
Okay, sir. So, if citizens across a couple of states are aggrieved and wish to file a PIL, can they approach the Supreme Court directly? Is there any exact factor which determines whether it should be filed before Supreme Court or High Court? This Supreme Court High Court issue people are asking. I'll say a related question also that
Yes.
If a PIL subject has nationwide implications, then should I first file it in its High Court as a test case, and then can the High Court refer me to the Supreme Court? Or should I go to the Supreme Court
No, I
after?
think there are some issues which ideally should, as a lawyer, I would say ideally should be first tried at the High Court, because you always have one more chance before the Supreme Court in a court of.
So would you recommend that process, sir?
It is not. I mean, it depends on the facts of a case. It can't be a general recommendation. But there are some issues which like the migrant workers issues all over India. If it's a national issue, then I'm sure it has to go to the Supreme Court. But
Right.
Delhi High Court also is a good place, because Delhi High Court houses most of the central government ministries, and they have jurisdiction which is almost as good as the Supreme Court on enforcement of fundamental rights. So that would also be a good option.
Got it. All right, everybody. Thank you very much for being there.
Thank you.
Most people have given good feedback. Yashashwani, you said the answers were not clear and to the point. So, okay, got your feedback. And thank you, everybody. See you all next time. We'll keep you posted on new sessions. You keep participating keep watching the webinars group. Procedural aspects is something that people have requested that they would want more on. So we'll keep that in mind, everybody.
I'll send you something on that.
Okay, sir. I'll post it in the group then as a document. Thank you, everybody. Bye.
Thank you.
Cheers.
Bye.